Too often, third-party litigation funding is described as an entirely new development that departs from established legal traditions. This description is a way to make third-party litigation funding seem less legitimate and more controversial. But in recent years, there has been no controversy when lawyers have received non-recourse funding to cover litigation costs. Of course, the contingency fee is one way that lawyers have, in effect, provided financing to clients. In a contingency fee agreement, the lawyer advances his services in return for a share of the client's recovery. In many cases, the lawyer will also advance litigation costs, such as expert witness fees and discovery costs. But the lawyer gets no guarantee that he will be compensated for either the services or litigation costs. In the last few decades, in cases where litigation costs are extraordinarily large, lawyers have found ways to obtain financing for those costs when the client is unable to cover them. In some situations, especially mass tort cases, lawyers have created financial partnerships between firms to share litigation costs and the contingency fee. For example, in the 1990s, the plaintiffs' lawyers in the tobacco litigation created a common fund to cover litigation costs. The financial power from this common fund helped bring about a successful result. Similarly, in the recent litigation against American Home Products involving the diet drug fen-phen, one attorney was representing thousands of plaintiffs in parallel cases. He became financially depleted while waiting for some of the proceeds from the early settlements. To cover this shortfall, he partnered with an experienced and well-funded plaintiff's attorney who contributed $2 million in return for a 7.5% share of the contingency fee. The cash flow permitted the plaintiff's cases to go forward to a successful result. In the last few years, investors have begun to offer non-recourse funding to lawyers in potentially lucrative contingency cases. When the case does have a successful result, the fees paid to investors can be quite large. Non-recourse funding to lawyers has not drawn the same kind of hue and cry that accompanies non-recourse funding to plaintiffs. Given that the differences between these two kinds of funding are nominal, it is hard to understand why there should be controversy about such funding when it goes to plaintiffs instead of lawyers. Indeed, it seems the opposition to third-party funding for plaintiffs is not the product of devotion to legal tradition. Instead, it seems more like an attempt to preserve the status quo that favors defendants. If you need help with litigation funding, call or email me today